clear about when the application is being issued. The application, if it's in the Ontario Court of Justice or the Unified Family Court, will actually have a first appearance date put in, which will advise the respondent that the first appearance date in this matter is X date at X time. Okay, that date is noted on the first page of that application if you're in an OCJ, Ontario Court of Justice, or UFC matter. Okay, now the first appearance is your actual first court appearance, because the MIP happens online. It's a video presentation, and there's a chance to an opportunity to ask questions. So I always say the MIP is a really good opportunity to ask questions too about general information. You can't get specific legal advice, but it's a good starting place to start getting information.
Right.
When your first appearance date comes up, it will be held before a clerk of the court, not a judge. Okay, so your first appearance at court will not be with the judge, it's with the clerk. The first appearance clerk reviews the court file to make sure that each party has served and filed all the documents the rules say need to be served and filed by that point. The clerk will confirm the parties have completed and attended their MIPs. And then if everything is complete, then the clerk will set the matter to its next step in the process, which is a case conference. If either party has not completed their MIP, or if the respondent needs an extension of time to file responding materials, then you can actually adjourn the first appearance. So you're coming back before the same or the clerk of the court on another day. So you're still at the first attendance or first appearance stage. And then depending on your court location, your first appearance may be virtual or it may be in person. So we are actually doing this video, we're recording it in mid-September. I've just heard that in Ontario Court of Justice jurisdictions, as of October 10th, MIPs, or not MIPs, the first appearances are going back to being in person.
Oh, I see. Okay.
Now, because of COVID and in most of the locations in Southern Ontario that I deal with as well, these first appearances are done all virtually. But in the Ontario Court of Justice, they're going back to being in person, except for a couple of northern regions in mid-October, which will be interesting.
Yeah.
So your first appearance may be virtual or it may be in person, but the court that your matter is proceeding in will let you know what to do. And if you need to log in, it gives you the login instructions. Or if you have to attend in person, it'll tell you where to go. Okay, if your case is in the Superior Court of Justice, not the Unified Family Court, but just the straight Superior Court of Justice, or you're asking for a divorce, or you're asking to divide property, then a first appearance date will not be set out on the application. And then the parties will actually have to take the step of asking the court to give them a case conference date, because so they can they skip that first appearance one. But then it's up to the parties to decide when they're going to go back to court on the next step, which is the case conference. Okay. So now we've had the documentation's been done, served, and filed. Parties have completed their MIP. They've gone through the gates of having the first appearance clerk check to make sure everything is there and in place and ready to go for the next appearance before in the court, which will be the first appearance before a judge, and that will be at a case conference. So the case conference is your next step in the process. Case conference is usually the first meeting the parties will have, if they're either with their lawyers or without them, in person or via or virtually with a judge. And the point of the case conference is for the parties to get together with the judge to explore issues in the case and to see if there's any way of resolving those issues. In order to prepare for the case conference, each party must prepare, file, and serve a case conference brief, which is a Form 17A under the rules. And you've got to do that brief at least 6 days before the conference date if you're the person that had initially got the process going or requested the case conference. And then the other party has to serve and file at least 4 days before the conference their own brief. So when you're at the conference, it's a more informal proceeding. You're not getting up and giving evidence under oath or testifying or reviewing, like everybody's reviewing documents because everybody's read and reviewed everything that's been filed so far. But at the conference, the judge is there to discuss issues the parties can agree on, to see if they can narrow down and define the issues that the parties don't agree on, whether there's any chance of resolving those issues they're not agreeing on right now by another method, such as going to mediation or arbitration or having an assessment done or something like that. And then ultimately how the case should move forward. So basically what happens, it's the chance for the parties to get together with the judge on a pretty informal basis to get the benefit of the judge's experience, who's going to talk turkey, as I put it, to both parties, but saying, look, what you're asking for, I can't see that happening. I think this is not a realistic thing to be asking for. Maybe you might want to consider perhaps a different approach or doing something different. If we're talking about property issues or support issues, quite often there is a lot of additional disclosure that may not be specifically required under the rules, but is needed in order to figure out how the division of property is going to work, or what is needed in order to determine, for example, income, if there's a dispute about what somebody's income actually is. Like this will quite often happen when somebody is self-employed, or if they have a closely held family corporation or whatever. So the other thing you do at the conferences is you can sit down with the judge, and the judge can make orders about disclosure for other documentation that needs to be produced, so the parties can see exactly what's going on to help them figure out if they can resolve these issues without having to go to a trial on them. Okay, if a party doesn't serve and file all the necessary disclosure or the documents required to that point, then the judge can, as I said, make an order for disclosure. The judge can also make an order for costs. If somebody has wasted the court's time and the other side's time by not being ready to proceed with the conference or do what they're supposed to do to that point, there can be an order for costs made against them. Judges also at conferences then, for the things that are working well, for anything that's agreed to on consent, the judge can at that point get make an order on consent for what the parties have agreed to. If it's a consent to an order that is going to be a final basis, that takes it out of the whole court process, because you can get a final order on consent at an early stage, which means you don't have to worry about bringing that issue back to court to be talked about, because you're getting it dealt with. You don't have to talk about it on another day. If not are resolved at case conference, then the matter will move on to the next step, which is a settlement conference.
Oh,
okay. In a settlement conference, it's pretty much a repeat of the same process for the case conference. You do have to do, each party has to prepare a brief. This is a Form 17C. Additionally, what you need to do for a settlement conference is file a certificate of financial disclosure. So this whole thing about financial disclosure becomes very, very important when you're dealing with support and property issues.
Yeah.
So if those are issues in your case, you will actually have to serve and file a certificate of financial disclosure on the other side, which confirms saying, I have provided you with the following financial documents.
Oh.
And that gets filed with the court. And then the other side can either agree or disagree about whether in fact those documents were produced or not. And it'll also be very clear about the documents that are mandatory, that must be produced. Like one of the mandatory things that you'll see is in a family law case, when you're talking about support, whether spousal support or child support, if your financial statement has to have attached to it your three most current year income tax returns and notices of assessment and proof of your current income.
Right.
And those would be all part of the things that are included on your certificate of financial disclosure. Right. If you've been required to produce bank statements or credit card statements or mortgage applications or anything like that, those would all be listed on the certificate of disclosure as well. And also what you're required to do at a settlement conference that you didn't have to do at a case conference, you actually have to prepare and serve an offer to settle. And you attach a copy of your offer to settle to your settlement conference brief. So you can show the judge that you're actively trying to figure out a way to get this thing resolved without the thing having to proceed to trial. So you do have to attach that offer to settle.
Wait, hold on. I'm shocked. I am. Yeah, because you have to make an offer. I always thought the offers to settle are voluntary.
Not in the family law process. If you cannot get all your matters resolved on consent or taken off-road to get you out of the litigation process, at the settlement conference, the court is starting to drill down a little bit more on saying, you should be doing everything possible to get this thing resolved without having to go to trial. So yes, the rules do require that at a settlement conference that an offer to settle be served.
Wow.
Okay. Now, it doesn't mean the other side has to accept it, but it means you have to present an offer to settle.
Okay.
But all the rules about offer to settle are the same as what they are in civil litigation. Like it will be attached to the settlement conference brief. The judge is going to see it, but the judge that hears conferences will never, ever be the judge that hears the matter when it goes to trial.
Yes,
you're basically dealing with a judge that's coming in and giving his or her benefit and experience in helping the parties to try to reach a reasonable resolution by being able to say, look, if I was the judge hearing this at trial, there's no way you're going to get that. Or this is an unreasonable position, but did you think about whatever? And again, going back to the person saying, look, do you really want to litigate this stuff and take a chance on what a judge might end up ordering? Or would you rather go to mediation where you're in control of the process? And you will be asked about mediation at every step of the process as well.
Right.
But again, because this matter is now one step closer to trial, now you are going to be required at your settlement conference to have served an offer to settle. The judge that sees that offer to settle, though, will not be anyone that would be hearing the matter for trial. If the offer to settle is not accepted, it gets taken back by the parties. It does not stay in the court file. It remains privileged and confidential, and nobody will ever know about what was in the offer to settle if it wasn't accepted, other than the parties and the judge that actually heard the conference.
Got it.
So again, it's another step to trying to say, what can we do to stop this matter from going to trial?
Interesting. Okay.
If you still have outstanding issues that cannot be
Right.
resolved on consent at the conclusion of a settlement conference, and again, you could have, and there's nothing that says you can't have more than one type of conference in a case. So you might have a case conference, and if there are things that are going back and forth about more disclosure that's needed, and you're going to give the other party a chance to produce it, and so then the other side can then think about what they get, you can adjourn a case conference a number of times. It's the same thing. Then it moves to the next stage, which is the settlement conference. A settlement conference may adjourn to give parties a chance to get the disclosure done if it's been ordered, trying to get things resolved without taking it to the next step.
Wow.
People might want to reconsider their positions and adjourn to a further settlement conference and do an amended offer to settle. So that can happen. You can have more than one case conference in a file. You can have more than one settlement conference in a file.
Very interesting.
But if you get to the end of the settlement conference and there are still outstanding issues that the parties cannot resolve on consent, and another settlement conference seems to be pointless because the parties are dug in and they're entrenched and they're saying, nope, we're not going to go there. We're not going to be able to get this done by agreement. Then the matter moves a step closer to the trial, and that is your third type of conference, which is a trial management conference.
Oh, okay.
So you've got three phases of conferences. You've got a case conference, you've got a settlement conference, and you've got a trial management conference.
Okay.
Trial management conference is where you start really getting the nitty gritty about saying, folks, you haven't been able to resolve this issue. You're going to go to trial. What is that trial going to look like?
Oh.
So in order to prepare for your trial management conference, each party must prepare, serve, and file the following documents with the court. A completed trial scheduling endorsement form, which actually goes through. It's a three-parter. Part A is for the applicant to complete. Part B is for the respondent to complete. Part C is for a judge to complete. Because what the trial scheduling and endorsement form does is that's where it sets out what is the plan for the trial in this matter. So applicant, who are the witnesses you intend to call?
Right.
What documents at trial do you intend to introduce? What experts can you agree to have a report filed with the other side? What else do you need to have done before you can actually go to trial? How much time do you think it's going to take you to run your part of the trial? So the applicant goes through and gives all that information, basically setting it out, confirming what the issues are that are going to trial, confirming if there are still any disclosure issues that are outstanding that may have to be dealt with. And then part B is completed by the respondent. And then part C is the judge goes through, reads what both the applicant and the respondent have said, and if they think there's additional things or that parties have gone way out to lunch on things that they've anticipated doing, the judge can step in and say, no, I've reviewed what the applicant and the respondent have said. This is what my view of this matter is for going to trial. One of the big things that people constantly do all the time, if they cannot resolve their matters on consent and there are outstanding issues, I would say 90% of the time, they underestimate the amount of time they think it's going to take to have this matter go for trial. If you have an applicant who's intending to call 6 witnesses and you have a respondent that's calling another 8 witnesses, you are probably talking about a minimum 3-day trial. And you'll have somebody go through and do all this stuff and they'll say, oh, well, we can get this trial done in a half day.
Right.
And the judge is going to look at that and say, don't think so. So that's where, with that final trial management conference,
Right.
You've served and filed the trial scheduling endorsement form. Again, you are required to serve an offer to settle with respect to all issues that have not yet been agreed to.
Oh.
And this is an interesting one. I always keep forgetting about this because I don't see it all the time. You're also required for the trial management conference to serve and file an outline of your opening statement of what you intend to say at the
Really?
trial.
Wow.
Now, that I don't see all the time. I don't know if all courts require it all the time.
Okay.
I'm not sure what the feedback is on that, but usually under the rules, that is one of the requirements, that you include an outline of your opening statement for how you intend to say when you start your trial. Okay, at the trial management conference, the parties really need to be prepared once again to see if they can agree on any of the outstanding issues. The party has to be able to confirm that that party and that party's witnesses are ready to proceed for trial as scheduled, and to confirm whether the time you've estimated for your trial in your trial scheduling endorsement form is actually correct. So like I said, so a trial management conference is literally just saying, okay, we will confirm these are the outstanding issues. These are the things that are going to be fought over at trial. This is the evidence you intend to call. These are the witnesses you intend to call. These are the documents that you're going to have there. And how much time do you think it's going to take to do your case? So then the court has an idea for how much time to set aside for the trial itself. You had your hands up.
Yeah. Is this judge at this trial management conference, is this the trial judge, or is it a case conference judge?
It's another conference judge. It's not a case conference. A case conference is way down the road. So there are 3 steps conferences in a case. There is a case conference, settlement conference, trial management conference.
Oh, so this is a conference judge. Okay.
It's but conference judges are also trial judges. It's just that once a judge does a conference in a case, that judge cannot and never will be the trial judge.
Oh, got it.
Because you're going to see offers to settle. You're getting into
that's right. Yes.
really heavy-duty conversations with
right.
Now, the one thing though is, again, depending on the jurisdiction you're in and the court resources that you have available, in most jurisdictions, if they can, there will be a case there, you will have a judge who they will try to be the one that hears every conference in a matter when it comes up.
Right.
So it can't always happen, but there are a lot of jurisdictions where they really, really try that once a judge has been the judge that attended with the parties on a case conference, they will try to get the matter to come back before that judge again.
Makes sense.
It's not always going to be possible, even though we're in the jurisdictions where it's a preferred method of proceeding, but it's a goal that they will aim for. There are other jurisdictions where it's complete crapshoot. Like once you've been through a conference, then when you're preparing for your next conference, there's been no efforts to try to schedule the judge that heard the case conference to be the one that hears the settlement conference, or the one that heard the settlement conference be the one that hears the trial management conference.
Yeah.
So sometimes it'll actually even happen that you can truncate or cut in half the trial management conference. So you can deal with the stuff about the outstanding issues and offers to settle and all of that. So you've really, really isolated. These are the things that are going to trial. You know who the witnesses are going to be. You know what the documentary evidence is going to be. And sometimes there are some jurisdictions where then you actually do have a trial judge that steps in. And it's a trial judge that's saying, okay, when this matter is set for trial, I'm going to be the judge that's hearing it. My trial, I'm going to be involved in confirming what the last steps are for how this trial is going to turn, like how it's going to proceed. What's necessary, what's not, what are you going to have to do? And again, that depends on the jurisdiction you're in. But the judge that is going to be doing the trial will never, ever see any of the offers to settle that have been exchanged, and they will never have been party to the settlement discussions leading up to that point. The judge that's doing the trial is going to be coming to the trial with fresh ears and fresh eyes on the case.
Okay. Sounds good.
Okay. Now, I guess, really briefly talk about another conference that might be available, and it's available in a lot of jurisdictions, but not all of them. And it actually happens back before you have your case conference with a judge. And it's called the DRO conference, which is a dispute resolution officer conference. So again, it's trying to thin down and get rid of matters that really do not require judicial resources. So if you're in a jurisdiction that has a dispute resolution officer, what happens is the first appearance clerk, instead of setting the matter for a case conference, if the parties are ready to proceed, will set it to a DRO conference, dispute resolution officer conference, which is yet another chance to try getting stuff done before you start taking up a judge's time. So in the jurisdictions that do the DRO conferences, the dispute resolution officer is usually a senior member of the family bar, lots of experience in family law matters. And it's the DRO will sit and meet with the parties to make sure they got all their ducks in a row and lined up. They've got more experience. They can give more information. They will not provide legal advice, but they can give more information to the parties about how to prepare to get in front of a judge on the actual case conference. DROs, the difference is they're not judges, so they cannot make orders, but they can have that discussion with parties to make sure that if there are disclosure issues that are outstanding, they can help the parties set timelines for when documents should be exchanged or whatever. And then when the DRO is satisfied the parties are ready for the next step, which is to go before a judge, then the DRO can then have the parties get the date set for the judicial case conference. So it's step. The reason I didn't talk about it right in the normal flow of things is because not all jurisdictions have a DRO program, but I think most of them are getting it now. But again, it's still one more chance of trying to narrow down the issues, focus on what really, really is still in dispute, focus on disclosure issues that need to be done, and get as much done as you can before you actually take up a judge's time, because we don't have enough judges and they're really, really busy in doing what they do. So you're trying to get them as well set up as possible to do what they can for you when you actually get in front of the judge. Okay?
Question. Okay, so for the jurisdictions that do have the DROs, is it mandatory to do a DRO conference?
Yes.
Oh, interesting. Yeah, so I see that.
But again, okay, if you're in a jurisdiction that has a DRO, and they are built into the court process, then there will be. Remember, I talked about each region has court practice directions.
Yes.
If you're in a jurisdiction with a DRO, the court practice directions will say, in some jurisdictions, it may not be all types of issues need to go before the DRO. Or they will say what issues can go before DRO, which ones can't, depending on what the issues are that are there. There are others that say, regardless of what your issues are, you will always go to a DRO conference. So again, you can always ask the court for an exemption to not do a DRO conference, but usually it's part of the process. But if it's in your jurisdiction, it will be built into the process by way of a practice direction, and it'll tell you when you need to go before a DRO and when you don't. But if a DRO program is there, you will likely have to go through the DRO process. It's not optional.
And for viewers out there, I will have a link to the practice direction. I think people are sometimes confused because there's the family law rules, and on top of knowing the family law rules, there are practice directions that I think.
But remember, practice directions are per region. What the practice direction is for the court, for the Superior Court of Justice in Toronto, is not going to be the same practice direction. There are provincial court practice directions, and there are other ones that are specific to a court location.
Yes.
So you might have a court practice direction that applies in Windsor that the lawyers in Windsor have to follow, that's different from something on the same issue in the Toronto courts. But always, when you look at the court practice directions, it'll tell you right across the top, is this a regional one, so it only applies in this region? Or is it a provincial one, which means every court has to do it? And it'll tell you whether it's Superior Court or whether provincial court.
I will have the links for that.
It's interesting, yes.
Okay, go on.
Lots of details and technicalities.
Yeah, for sure.
Okay.